This is the Tea on International Arbitration with Nicole Silver and Gaela Gehring Flores. Nicole Silver and I are practitioners in the field of international arbitration, and we are both chairs of two committees of the DC Bar International Law Community. And we are back at you with the Tea on International Arbitration, where we aim to give you bite-sized information regarding international arbitration topics of interest. Nicole, would you like to introduce our illustrious guest speaker today?
I would love to. And to be honest, I feel like our guest today is really the kind of man that needs no introduction. But for those of you who don't know him or don't realize just how much he has accomplished, let me give you a brief background about Patrick Pearsall. Patrick is a partner at Allen and Overy. He is also an arbitrator listed on the ICSID roster. He is the former Chief of Investment Arbitration for the United States. He has also worked at the ICC in Paris. He's a teacher at Georgetown Law. He is the former TPP negotiator and the current advisor to the UK government on international investment law. And finally, besides being a great guy, he is also counsel to the UNHCR, which is the UN Refugee Agency on US asylum ban. So with that introduction, thanks so much for being here today with us, Patrick, and we're really glad to have you as our guest.
It's my pleasure. Hello to everyone. Happy to be a guest on the Tea.
Thanks, Patrick, for being on, and I'll just start in with our questions. Patrick was nice enough to let Nicole and I simply kind of chat with him about some topics that we thought might be of interest to you and maybe a bit provocative, because I like to be provocative. So here we go. Patrick, quite a few years ago, and at least before the 2016 election, you and I found ourselves at the APEC summit in Peru, talking quite a bit about the TPP and the spaghetti bowl of investment treaties. So, if you now could go back in time, in a time machine, and you could only tell yourself 5 words, or maybe 5 brief phrases, if you could only give yourself those 5 things to prepare yourself for the future of public international law and international arbitration, what words or phrases would you employ?
Wow. Well, that's a daunting question. January feels like a lifetime ago, so I can't even begin to comprehend how far ago 5 years seems, but a lot obviously has changed in the last 5 years, and encapsulating that into 5 words is a tough choice. And if I had a time machine, I'm not sure if that's the place that I would go to, but let's play the game. I think that the first word perhaps would be populism, because I don't think that we fully, at least I didn't fully understand the progress or the march towards populism that had already begun, and how populism would change our practice. Another word I would put in the mix would probably be nationalism, which is adjacent to populism but distinct, and I think both of those together are really of a character with regard to what we're living through currently. So populism, nationalism. I would put reform on the list, and public, which is different from transparency. I think the distinction I would probably hope that my 5-year younger self would make is that transparency is one aspect of international arbitration practice, but public, the kind of awareness of people outside the field of what we do was going to really increase and characterize kind of how we understand arbitration 5 years hence. And then the final word would be anxiety. I think that there's just a lot of anxiety around us generally, but certainly in the field itself. It's a kind of existential anxiety. It's a kind of anxiety with regard to whether the underlying theses of protection as promotion and whether foreign direct investment itself is a universal good, all of those are now being re-examined, and there's some anxiety around that re-examination. So I guess those 5 words, what did I say? I said populism, nationalism, reform, public, and anxiety. So in the password version, game show version of international arbitration, hopefully someone 5 years ago listening to that would say investment arbitration as the answer to those 5 clues.
Wow. that no, that is impressive. I must say, playing the game myself, I was not able to come up with one word prompts for my
Well, what are your phrases then?
My first phrase is Trump wins, impeachment fails. I honestly think that my pre-2016 election self would have been just, yeah. And then I have RIP TPP. And then Netherlands model bit loophole. And I thought, because I always think of the Netherlands bits as kind of the loophole that allow a lot of investors from around the world to gerrymander themselves into investment arbitrations, that they're preferable bits. And I thought maybe that phrase would get me thinking, like, wait, what? The Netherlands is going to change its model bit? That would be interesting. And then I have 50-foot Ethernet cable. Because that is my life these days, making sure I have a very secure internet connection for all of my virtual arbitration hearings and Zoom calls. And the last one is questions for podcast.
Those are all great. I think from a veil of ignorance, if we put all of those into a jumble, we would have a really enjoyable night drinking piscos, trying to figure out what the heck the future will hold for us. So those are all very good. What about you, Nicole?
So I sort of forgot to play the game, but I think in listening to you guys, the 2 phrases that each of you used that really stood out to me were, wait, what? And also anxiety. And I'm wondering, I guess, Patrick, to go back to your 5 words, how much of anxiety and this idea of how little you could have predicted arbitration coming into public view and tying that into nationalism and also populism, how much of it do you think is really, I mean, to me, all of a sudden, those words have negative connotations and what's happening with our field today. And all of that coming into being, it seems like this vortex that's surrounded by a lot of anxiety. And I'm wondering, is there a way to sort of see through this and to find good and to understand maybe why transparency is good, but sort of being in the public eye maybe is not as good? And if things have gotten a little bit out of control, to get to the place where it is an anxious state and where we are at a place where we just say, wait, what? How did we get here?
Yeah. Well, I mean, if you were to take my list, which I don't want to spend too much time kind of parsing, but I think populism and nationalism are cousins on that list. And I don't necessarily think that certain aspects of those are always universal bad traits. That's not to say that I'm defending either of them, because I'm not, but I just think that those are really complex isms, and they're not kind of monolithic in how they should be understood globally, and certainly not in the geopolitical environment. And I think reform, public, and anxiety are all related on my list too, to one another. And with regard to anxiety, I guess it depends on where you're sitting, whether you think reform, public, and anxiety are words of concern, or if they're kind of necessary words of interrogation at this point in our history. So what I mean by that is I do think that in 2015, 5 years ago, some understood, and many in the community should have better understood that globalization left folks behind, and that states and regulations were catching up with where those states thought the public good was, and that would eventually potentially come in conflict with some of the obligations that states undertook through bilateral investment treaties and FTAs, and that interrogation, that kind of anxiety around what a post-cosmopolitan world looks like on the kind of what has globalization left behind, that would necessarily come home to our field. What I don't think many of us predicted, or at least I didn't, and I don't remember anyone in 2015 really talking about it, although I'm sure someone listening to this podcast who wrote about it will write you guys or me and let me know. But what I don't remember is hearing or thinking that ISDS or international arbitration generally was going to be a poster child for the discontent about who are winners and who are losers in globalization. So, that is a surprise. And I think that if we were better prepared in 2015, we probably could have done a better job of responding to that. Certainly in the Obama administration, I think that it would have probably changed how we rolled out TPP generally within the United States. So it would have been good to be more thoughtful about that in 2015. But I guess the takeaway from all of that is we are where we are, and reform, public, and anxiety are kind of here to stay for a little while. And I think that that's not necessarily a bad thing. It's just how we deal with that anxiety that is most important. And I mean, one way to do it is kind of a separate question I had, which is what do we tell the next generation of international arbitration practitioners? So I mean, if we could speak to international arbitration students now, 1Ls even, or first years, what would we tell them to be thinking about for the next 5 years? Like, what would your 5 words be? And I've thought about posing this question to you, so I'll just go with my 5 words, and then I'll let you both chime in.
Please
I
do.
would say diversify would be one word. Regional, security, avoidance, and school. Those are my 5 words. So am I allowed? Do you want me to stop there, or do you want me to go through why I think those are 5 words for the future?
I think I'd like to hear your explanation. That'll give me a little bit more time to think of mine.
Well, you can do phrases. RIP TPP. That one burns. Especially.
Yeah. No, I mean, yeah, definitely, absolutely, no offense meant to you.
No, it's
It was
fine.
sad.
Elections matter.
Yeah.
So diversify. I just think that the era, to the extent it ever existed, of having a pure investment arbitration treaty practice is really coming to an end. I think that the field is still growing, and I'm not saying that it's not going to be a robust field in the future. I just think that if you are in law school or a first year associate, and you think that all you are ever going to do as a practitioner is investment treaty work, you should be thinking about diversifying that, because the world itself is looking at how to protect investments in creative ways, and you need to be a lawyer that is responsive to kind of how the world is looking at the protection of investments, and it's not just through BITs. So diversify. Regional, I do think we are moving back towards, perhaps we never left, but we're moving back towards kind of regions of influence, and kind of the geoeconomics of the next 10 years are going to be probably defined by what region the capital and the funds and the investments are in, and the set of laws that govern that region. So again, TPP, Europe, etc. Security, I do think we have a growing intersection of how foreign direct investment and security, economic and national security, interplay. I think there's a real, it continues to be a very hot topic. And it's no longer, I think, the case that people believe that foreign direct investment is a universal good. I think it's who is investing, where are they investing, why are they investing? Those questions are much more in the minds of policymakers. And I think that that's going to characterize more of our work in the future. Avoidance, I think clients are much more interested now in bargaining in the shadow of law than they have been in the previous 5 years or even 10 years. I think that many more disputes are not seeing the light of day, which is probably a good thing if you think about it, but avoidance is going to be a real key component of our practice, I think, 5 years from now, and that includes mediation and all the kind of prophylactic aspects that you can do to protect investments without going to disputes. And then school, and this is the one I'm perhaps most excited about, is I do think and I hope that the future generations do something that I think my generation has not done as much as practitioners, which is create a school of international law that will help kind of bring us forward in the future. I think that because of the impact of investment arbitration on public international law, some of the better public international law minds have occupied themselves with the Pacific settlement of disputes through investment arbitration, which is not a bad thing, but it's also sucked up a lot of the bandwidth for us to be kind of creating a new school of thought about how international law will govern the kind of interaction of nations in the future. And I think I'm hopeful that the next generation will play a bigger role than my generation has on those questions. That's not to say anything against the many thoughtful academics that are working on this, but from a practitioner's standpoint, I think we could be doing more.
Nice. So my 5 words or 5 phrases. I first start with so what do we tell a 1L, or what practice will be like in 15 years time, or how to prepare for practice in 15 years time. And these are my words. So first word is advocacy. Second is a contraposed or contraposition, which is diversity, status quo. And the next contraposition is evolution, revolution. And so the first word, advocacy, for me is just that's what I always tell law students who are interested in international arbitration. They always ask what classes they should take, and I always say, you should really be the best advocate that you can. So if there are any trial practice classes, any trial advocacy classes, seminars, workshops, what have you, you should take that. And I don't see that changing, except, maybe maybe the contraposition there would be advocacy, mediation. That there needs to be more education and awareness with respect to true alternative dispute resolution mechanisms. I think a lot of people tend to think of arbitration as this very alternative route to dispute resolution, and it essentially is litigation. So, learn about the mechanisms that you're going to be using. And if you're going to be an advocate, if you're going to be practicing advocacy, well, learn how to do that. Or you could also learn about mediation and becoming a mediator. And then the second one, with respect to diversity versus status quo, I think that essentially, unless things change, I think our profession's going to stay a lot the same. We're going to have a lot of the same criticisms, a lot of the same comments about who are the arbitrators and who are the practitioners. And it's a lot of the same people. There's not a lot of diversity there. So unless that changes, and maybe the current Black Lives Matter movement and increased awareness of white supremacy generally in the world, maybe there's a little bit of light at the end of that tunnel. Maybe people are actually taking note more and more and seeing just how important issues of, racial, gender, equality and justice are, and how you really need to kind of get your own house in order if you want things to change. And then the evolution versus revolution, kind of along the same lines. I think we've been told and kind of thought for a long time that, well, things will get better little by little. And, they kind of do. They kind of do. So someone preparing for a practice in 15 years maybe could be preparing for a practice that has only evolved a very, very little bit. Or maybe it'll be different. But I think a lot depends on what happens and how seriously people take the racial justice question. Anyway, Nicole.
I think that you just touched on a subject that I was going to ask you both about. And I think in the interest of time, I'm going to jump to it. And so we were just speaking a little bit about diversity. So I am going to ask you two, what kind of magic wand do you think is necessary? And I'm assuming you are both going to agree with me here that there really is not a lot of diversity in our field. So what kind of magic wand do you think is necessary to improve diversity and inclusion in terms of race, gender, and sexual orientation in our field? And do you think that the various pledges that have been circulating are effective? And really, have you seen anything that works? Let's start with you, Patrick, our guest.
Ooh, it's a tough question. Obviously, there is no magic wand. I wish there was, but to a certain extent, even a magic wand wouldn't do it, because I think part of the journey of getting to a field that is more reflective of who we are as a global population is part of the process of understanding that it takes constant commitment and work, and that we need to understand why diverse views matter, diverse backgrounds matter. So in certain respects, a magic wand wouldn't even get us where we need to be, because we need to do the work to get there, if that makes sense. I think that the most powerful tool that I've seen is when clients demand it. That's been very helpful. So, internally you can put together a team that you think is great, but if a client doesn't like it or doesn't want it, that's not going to end up working. And I think it's important to hear from clients that they demand diversity. And I think that can be helpful in a systemic way for folks who aren't already staffing their teams with diverse lawyers. And then just a personal commitment. And this is where I do think that some of the pledges have been very helpful, because I do think that you make a personal commitment to yourself not to, for example, put arbitrators in front of a client that don't include diverse candidates. If you do that because of a pledge, or you think of it because of a pledge, that's great. But I think the next step is explaining why to the client the list looks the way it does, and why some of the people on the list are ones that should be taken seriously. I think that's important. So I guess where I would do some of the work, in addition to recruiting, and it's all systemic, starts at law schools, et cetera. But where I would do some of the work is in coming up with better ways to discuss diversity with your clients who otherwise aren't disposed to kind of welcoming that conversation on questions like arbitrator appointments or why you're staffing a team a certain way. Because I think there are really good answers. There's a really good reason why diversity across various metrics really matters to a successful arbitration. It's just a question of taking the time to explain that to a client, if that's answering your question. It's a really hard one, Nicole, so thanks. Thanks for that.
Yeah. We promised to be provocative.
We did. I think Patrick's absolutely right that you need something other than a magic wand, because you kind of need to go through it to truly be part of the experience. It has to be some sort of I'm going to use it again, hermeneutical experience. And a magic wand wouldn't get you there. I think a lot of the secret lies in not being afraid to talk about these subjects, to raise them, even if in our field, maybe people might react by saying that that's not a germane topic to international law or international arbitration. I think kind of continuing the conversation and insisting that it is in fact a germane topic to the conversation. Because if we're quiet on it, and if we buy the notion that this is not something that is raised in civil discussion, then it kind of dies. And I definitely think shifting the narrative from one of colorblindness to something more like racial justice, racial equity, racial and gender justice, racial and gender equity is really important in getting people to really talk about it and discuss it, and to no longer say no, that we don't talk about those things. That's not germane to the international arbitration field, because it very much is. So thanks for that illuminating discussion, Patrick, on diversity in our field. I have another provocative question for you, and it's in the form of a would you rather question.
Okay.
So, would you rather A, never again be able to conduct an arbitration over Zoom or phone, and whether we're talking about client calls, witness or expert interviews, or hearings, or B, never again be able to conduct an arbitration in person? Go.
Oh my goodness. It's kind of an impossible question. I think I'd probably take the never again to conduct an arbitration over Zoom or phone, and default us back to in-person only hearings. Now that's obviously not my preference. I think you need to do both, but if we had to choose one or the other, I think in person probably would be the way to go. Just for me personally, because I tend to enjoy my practice most when I'm in contact with colleagues, and I think we still have work to do as a field to build our community. And I think we've done good work in the last 5 to 10 years of community building, and that happens best when you're in person. But I also think from a client perspective, ironically, having in-person only hearings and meetings might actually lower costs, because most folks don't want to be away from their family for too much time. And if you are required to show up for 2 weeks, it's going to go for 2 weeks and not kind of spill over. And I think that there's a luxury that you have with Zoom and conference calls and things that can kind of tick over on the clock to a point of inefficiency. So it's hard to be really efficient on virtual platforms, whereas when you're in person and everyone's shown up, you're kind of held to account a little bit better. So from a client perspective, having in-person meetings sometimes I think can be more cost effective than having them virtually. But ultimately it comes down to the fact that part of the joy of working in this field is the coffees that we have and the conversations outside of this. And I think that we're a special community of lawyers who, whether you're an arbitrator or a practitioner or an expert, you're part of a community of folks who know each other. And I think that makes our field more enjoyable, but also probably better from a client perspective for the resolution of disputes. It's very rare that you're going to be in a contentious proceeding with folks who you are not going to see again. And I think that by and large is effective for a client, and why in part they chose arbitration, right? So in person, that's my answer. Final answer.
Thanks, Patrick. And Nicole, I seem to recall you mentioning a very particular answer to this.
Yeah, I would definitely say if I had the choice, if I had to make the choice, it would be to never conduct an arbitration over Zoom or phone. And I would definitely push for the in-person as well, if only, Kayla, for the tea sandwiches. Okay.
I don't know if I can take that answer. It's tough for me. Clearly, I am definitely an in-person people person, and there's certainly no substitute for cross-examining a witness or an expert in person. That's extremely difficult doing that virtually. And as exhausting as in-person hearings are, I think that Zoom hearings might supersede that. They might not. They might actually, yeah, be more exhausting. So I think I'll pick in person. Never be able to do it over a Zoom or phone again. Now, that said, I'm not exactly sure when we'll ever be able to get on a plane again and go to another country. But yeah, I like to be with people.
But just
That would
think
be
about how much joy we will all have when we rejoin our European colleagues and have in-person meetings again. I think it'll be, let's hopefully we can encapsulate that joy and kind of push it forward in a way that is going to benefit the field, itself, because I think there will be a lot of goodwill that comes out of this when we all get to see each other again, I hope.
agreed.
Yeah. So taking that and understanding that we're in this phase right now where we're all sort of realizing we're a little surprised where we've come and where we've come to be, and hoping that this is the time for change and to pay it forward a little bit. Let me ask you this, Patrick, as our final question before we let you go and make sure that this does not become one of the inefficient Zoom calls that you've been on. But so other than the pandemic and the fantastic failure of the US state in response to that pandemic, what's keeping you up at night in terms of public international law and or international arbitration? What's weighing on your mind?
Well, first, I will say I still have several good friends and colleagues in government, and I do think that there are things that the United States could have done better, but the United States is doing a lot. What keeps me up at night? It's a really tough question because obviously there's a lot of noise outside of the field that is noise in a good way, good trouble, as John Lewis would say. That is kind of my primary focus in certain respects. But I think within the field, the thing that worries me most is that we are not going to have a refocus in the kind of transition from globalization as understood in 1999 to where we are now. We're not going to, as practitioners, take up the mantle of selling international arbitration as an effective means of dispute resolution into the future. I mean, if you look at what practitioners were doing in the 1920s, they were holding all sorts of public meetings and things trying to sell arbitration to the United States and to the rest of the world as an effective means of dispute resolution. And it was in the 1920s a relatively populist movement of bringing access to justice to those who weren't necessarily able to appear before courts, and it was faster and more efficient, and all of those things that we learned in law schools as the hallmarks of commercial arbitration, which now a lot of students roll their eyes at. So I guess what keeps me up is whether we are taking up the mantle as practitioners to kind of create the next wave, the next kind of the future of international arbitration as something that will persist and grow the way it needs to be responsive to where we find ourselves in the world. So I guess that's a long-winded way of saying what keeps me up at night is what I think keep a lot of people up at night is, can I be doing more? Should I be doing more? And how do we do it? So, but those are just general anxieties that we all have, presumably. So I don't know if those are unique.
Thank you, Patrick. That last question is just for you. Nicole and I get to talk all the time about what keeps us up at night. So with that, I'll leave it to Nicole to word us out.
All right. So thank you to our guest, Patrick Pusall, and thank you to the DC Bar. To check out more of what DC Bar Communities has to offer, please visit dcbar.org/communities. You've been listening to The T on International Arbitration. Watch out for new episodes, and if you like this episode, please tell a friend about it and subscribe at anchor.fm/DCBarT, that's TEA, or anywhere you access your podcast.
If you enjoy listening to content such as this, consider becoming a member of the DC Bar Communities. Choose from 20 different practice area specific communities and connect with legal professionals from across the country. To learn more, visit dcbar.org/communities.